Legislators began scrutinizing the Constitutional Amendment Bill 2017 in the Legal and Parliamentary Affairs Committee. They specifically dissected the Land Amendment Act that has kicked up a storm across the country. The bill seeks to grant the government power to acquire private land for development projects before resolving the payments with the owner. The Deputy Attorney General Mwesigwa Rukutana and the Lands Minister Amongi appeared before the committee. Rukutana started off by stating the government's justification for introducing the bill.
To compulsorily acquire land from any individual for public use.
He also told the committee that the Constitution has other safeguards against land grabbing by powerful government officials.
We can put money intended to compensate the landowner or a person with property in land in court, pending the determination of whatever dispute or disagreement, and to enable him access the money.
Amongi stressed that the draft law is important to enable the government complete its projects without delays.
To avoid stalemate, where government cannot proceed with the infrastructure project because one or two project affected persons have rejected the value.
Everyone knows the clear procedure of compensation and no one is disputing it. Let her address herself to the new insertions and give justifications for those.
We have a single project in Ulisa which has been delayed because of land acquisition. No contractor, no project on site.
However, lawmakers demanded to know the urgency of the matter.
What is the urgency? What is the urgency that this bill should be considered now?
We are on record saying that constitutional amendments should be brought at a go so that the country and Parliament addresses them.
Later on, one of the MPs cited a procedural issue, arguing that the bill was supposed to be presented by the Justice Minister Kahindo Tafire instead of the Deputy Attorney General.
In your Constitution, the Deputy Attorney General deputizes only the Attorney General. The policy head of this ministry is the Minister for Justice and Constitutional Affairs. Forget about the mistakes that are made in appointment. We are not dealing with the greatest of respect, of course. We are dealing with the wrong person.
Justice and Constitutional Affairs, because I am aware he is also Minister of State, and he stated so in his introduction.
Assigned this to me.
The MPs put the Deputy Attorney General to task to explain why the bill was brought at this point in time, yet the initial agreement was that constitutional amendments would not be presented piecemeal.
The question should be, should we continue to listen to him in disrespect of the resolution of the House, or we say that thank you very much, we've had your presentation on this amendment, but we now seek your indulgence as our chairperson.
There was an undertaking by the Minister of State for Constitutional Affairs and the Prime Minister of this country. They made a promise to the country that this committee, which had traversed the country collecting people's views, was not doing that work in vain. They undertook to bring comprehensive constitutional amendments.
There is no way Parliament, or actually this committee, will sit here and make a report without talking to the owner of the land, especially if we are taking away this right.
It's at that point that lawmakers started suggesting that the minister should be sent away. The bill requires the government to deposit the sum of money quoted by the chief government valuer in court and carry on with its development projects as it awaits for the court to resolve the compensation dispute.
Then government has now an automatic right to take the land. Then it transfers the burden to the landowner to start running to court with all its others, which the land attorney general.
The contrary, streamlining how people enjoy their rights.
When you read Article 26, sub-Article 2B, it envisages you bringing a law under which you can compulsorily take possession of this land. And that law would cater for time and the time frame within which this can be resolved and the time within which you should pay and the right. Do you really need to amend the constitution?
Now, some legislators argue that government won't be having the capacity to clear out all the compensations that will be given to those that their land has been encroached on. This is basing on the fact that currently the domestic debt of Uganda is over 2 trillion shillings.
The domestic debt is in the region of 2 trillion. The domestic debt, what does that mean? Government is not good at payment.
Yes.
The domestic debt is 2 trillion.
Yes.
Attorney General, you have been coming to this committee year every year, and you've been saying you have quota awards amounting to 500 billion. Quota awards over 600. You have not paid. So the evidence that we do have is actually that government is not does not pay.
Later on, he admitted that the government would take people's land, but immediately apologized, saying it was a slip of a tongue.
Under the proposed amendment, can I explain? Under the proposed amendment, we are taking over the right to prior possession. The right to prior compensation.
So it was a slip of tongue?
It was a slip of the tongue.
MPs also tasked the Minister and the Attorney General to cite examples where a similar law has been applied.
I would want the Minister to give us examples of countries within and without EAC, where, first of all, the national constitution is like ours, especially provisions under Article 26 and 237, where land belongs to the citizens of that.
After several deliberations, lawmakers decided that the Deputy Attorney General and the Lands Minister be sent back because their arguments were not satisfactory. More research, NTV at Parliament.